Hi, welcome to my channel. This is going to be the second video in my new series, Fighting Back, Exposing CPS Corruption, where I show you my very own experience with Florida Department of Children and Families and the circus that it was. The first video, I went over the illegal seizure of my children, how the county sheriffs assisted DCF in illegally pinging our phones, GPS tracking us to a Walmart, illegally detaining us at Walmart, fabricating some poor excuse for a quote court order of illegally seizing the children and illegally initiating a case. And then it goes on from there and it gets worse. So I went over the whole fiasco at the Walmart. In the last one, showed you the documents. I will try to link that one below. I also have a 5-part, it's like 8-10 minute videos each about the whole story, the short version of my testimony, my experience with Florida Department of Children and Families. You can check those out if you haven't seen those yet. So on this video, I'm going to go over the illegal initiation of this quote case, which was a complete circus, and the actual proceedings and the legal procedure that they are by law obligated to follow and what they did instead. And I'm going to show you my documents. Okay, so first, just to recap, in Florida, the statutes on Chapter 39 is the definitions for abuse or neglect. For a child to be dependent, for CPS, DCF to come in and intervene in a family setting, there has to be evidence, probable cause of abuse, neglect, or abandonment. Okay. Abuse definitions. Child abuse means intentional infliction of physical or mental injury upon a child, an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of any person to commit an act results. And neglect. A caregiver's willful failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of a child. Okay, those are the definitions of abuse and neglect. And obviously we know what abandonment means. That wasn't even brought up. I'm surprised, but now this is from the actual police report of the quote incident that cited this whole quote investigation. The arresting officer put in the report, they conducted field sobriety tests on Melissa, be me, to ensure she was okay to operate a vehicle. She did not show any signs of impairment. Children were clean, well-fed, happy, and showed no signs of neglect. A research of ACES did not reveal any concerns regarding Melissa's history to include neglect or narcotics, which is not what they said at all in their CPS report. Imagine that, right? Okay, so the actual legal procedure that they have to, by law, oblige to is this. In Florida, under Chapter 39 Florida statutes, this is the process. 1, report intake. Somebody reports it, and if it meets the criteria, which it always does, CPI investigator is assigned. 2, investigation. CPI must start the investigation within 24 hours, must interview child, parents, sometimes teachers, doctors. The goal was to decide if the child is safe, at risk, or in immediate danger. They may also request medical exams, home visits, blah, 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 blah. 3, safety assessment. DCF completes a safety plan. If there are concerns, the child can stay at the home with conditions. If the child cannot safely remain at home, DCF may remove the child, place them with relatives, or in foster care. 4, if removal happens, the CPI must file a, quote, shelter petition with the Juvenile Dependency Court within 24 hours of removal. The court then holds a shelter hearing, which must happen within 24 hours of the child's removal. At that hearing, DCF must show probable cause that the child was abused, neglected, or in danger, and that removing the child was necessary to protect them. The judge decides whether the child will remain in DCF custody, go to a relative, or return home. Dependency petition. If the judge finds probable cause at the shelter hearing, DCF must decide whether to file a dependency petition to continue court involvement. This must usually be done within 21 days after the shelter hearing or before the arraignment date. And the dependency petition has to lay out specific allegations of abuse, neglect, or abandonment. Arraignment and adjudication. The parent is formally served with the dependency petition and must enter a plea, admit, deny, or consent. If they deny, a trial is scheduled. DCF must prove their allegations by a preponderance of evidence, which is more likely than not if the court finds the child dependent and moves to the next phase, case plan and review. Okay, that's what they have to follow in the statutes by law. Okay. So now I'm going to show you the actual documents that were filed in my case that are still in my case file that they used somehow on this case. It's ridiculous. Okay. So first we have affidavit to take child into custody. If you notice, it is typed up. Okay. They squeezed another name into the same line next to the first name, which is not normally how it would look. The reason behind this is because when they first started the case, they didn't know my other child's name and they had to go back in and edit everything because they didn't have a case. They hadn't talked to any of us yet. They just made a bunch of shit up. If you notice, there's only one F for female. There should be two. They should be on their own lines. And if they were supposed to be on the same line, there would be two Fs, but they're not. Okay, they squeezed in their birth dates together. You know, you see. It was stamped, allegedly, by the clerk of court at 4:31 a.m., which is interesting considering that the clerk of court doesn't open until 8. Right. The case number is written in because they didn't happen until later on, which means that they didn't legally have any authorization to do any of this. Okay, so next. So that was 4:31 a.m. supposedly. These times are important. Okay, now this is the order to take child into custody. So that was the affidavit that they file, and then they get the actual order. Supposedly, this is the one that they came up with later. If you notice again, the case number is written in by hand. Right. And now this one was, quote, stamped by the clerk of court at 4:00 p.m. that same day. Sure. And now we have the affidavit for placement in shelter. Also allegedly stamped at 4:31 a.m. before the clerk of courts opened. Isn't that weird? Now, if you notice on this one, my first child, who is also a female, is put as a male. And the case number, the SPN numbers are also written in by hand. And then right under where it says affidavit and petition for placement in shelter, where it says comes now on blank at blank. So that would be the date and time. It literally is blank. They left it blank. Okay. The reason that this first part is left blank is because it says on that date, the children were found within the jurisdiction of this court, which means they have legal authority to have any say whatsoever, which they never have and never did. Okay, that's left blank because they go to the next thing. There's an X. The children need to be taken into protective custody, which they cannot do if they were not found to be within the jurisdiction of this court, but they just skipped that whole part. Now, on the bottom of this affidavit and petition for placement in shelter, we have the notary, okay? The notary stamp would be over here to the left in that circle that's empty. It's missing. Where the notary's signature would be is some sergeant fuckbase, okay? And then his sergeant number. And then the petitioner's supervisor F base also. Then below that, we have supposedly some attorney's signature who you don't know who it is because it doesn't say any name. SPN's left blank. You get the point. Also, this was supposedly notarized 5/26, which is the same day of the incident. So less than 24 hours from when they got the call. They hadn't even talked to any of us yet. There was no investigation. There was no nothing. And they're already getting some notary supposedly to sign off on this placement in shelter for children that they don't have jurisdiction over and they never even determined to be in danger or in the jurisdiction of the court, which they are not and were never. Okay, so that was the affidavit for the order for placement in shelter. Now this is the actual order for placement in shelter, which you'll notice is also handwritten, not just the case number, all of it. And this one was allegedly stamped at 4:00 p.m. So now we have both affidavits allegedly stamped by the clerk of court at 4:31 a.m. on the same date, and both orders, both allegedly stamped by the clerk of court at 4:00 p.m. on that same date. So all 4 orders were supposedly issued and filed on the same date. Okay, that's important. Now, so you see the stamp, this sideways ass stamp. Then we got some attorneys' names, which is obviously in the same handwriting. I've blocked out the names for obvious reasons. And then over here on the right, you'll see that they labeled my children as transient and us as transient, even though they knew where we lived and went and talked to our neighbors there and also told them that we were on drugs and that's why they were looking for us and the children. Okay. And then below that, there's no one listed as the father on my older daughter's birth certificate. Mother has named her father, who has passed now, prospective father. Okay. Now this is important also because this is filed on the 27th, which would be the day after the incident and before they have actually illegally seized the children. I did not even inform this CPI officer that my older daughter had a different father until about a week after this date. Okay, so how on the 27th did they know? Weird, right? I don't know. No parent was present, written in on the bottom. Okay, there has to be somebody present for the most part. You know what I'm saying? Okay, next. The need for replacement, contrary to welfare, have been evading CPI contact. Okay, so we were evading their contact for a whole 24 hours. Okay, that's not even possible. You know what I'm saying? Okay, then below that, prior in-home services, never. We never had a case with them. We never had any services offered. You know what I'm saying? All of it's just complete. It's just lies, all lies. Okay, then after that, this is the next page. Is still the same order. The shelter review hearing is scheduled at, it's left blank. Why? Because we didn't get one, which is violation of due process. They have no subject matter jurisdiction. By law, they had to throw the whole fucking case out as soon as that came to the judge's attention. You think they did? No, obviously they did not. And then petition for blah, 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 arraignment hearing, 6/23. So that's almost 1 month late, 1 month before I even got to see a judge and tell him that I didn't get a shelter hearing. He obviously didn't care a whole bunch. Why? Because he's just like the rest of them. Okay, and then this is, again, on the bottom, this is a note May 26th, which would have been less than 24 hours after they got the call. Notary public signature, if you notice, it is a scribble. The date on before me and sworn and subscribed is written in the CPI's handwriting, which would not be done on an actual authentic notarized document. And the bottom part where it says personally known or produced in identification, type of identification produced, is left blank, which also is not something that would be done on an actual notarized document because it invalidates the notarization. An actual notary would know better. So obviously we're looking at forgery and perjury, just for starters. Okay, and next. So order for placement in shelter, except 4 o'clock, was, quote, stamped. Now, this is the actual procedure order that you would follow when opening and starting a case. 1, affidavit to take child into custody must be sworn before a court, issues pickup order according to Florida Statutes 39.401. Then you would have the order to take child into custody, and the court issues before the child is removed. Then the child would be taken into custody, which would trigger the 24-hour period for a shelter hearing, Florida Statutes 39.402. Then there would be a petition and affidavit for placement in shelter, filed promptly after removal, typically before or during the shelter hearing. And then there would be the order for placement in shelter, signed after shelter hearing, not before. And here are some of the many problems with these documents. Time of filing. Both affidavits were filed at 4:31 a.m. Like I said, Florida courts generally open at 8 a.m. So how were they stamped at 4:30 a.m.? Okay. Both orders were stamped at 4 o'clock p.m. same day. Order to take into custody and the order for placement in shelter should not be issued simultaneously. The pickup order comes first, the shelter order comes after the child is removed, and the shelter hearing is held within 24 hours. For starters, when any document is officially filed with the court, the clerk assigns a case number, and that number appears automatically on the filed copy and in the court docket. Florida Rules of Judicial Administration 2.520 and 2.525. So there should not be any case number handwritten on any document in a court docket ever. Okay. Only once the clerk stamps and logs the document does the court actually gain jurisdiction. Florida Statutes 39.013. When jurisdiction is not properly invoked, any orders become void. So everything they had has no authority, no jurisdiction, never did. Okay. So again, here's all your stamped by the clerk, and then the handwritten case numbers and SPN numbers. It's absolutely ridiculous to even look at these. Okay. Next, no certificate of service on any of these documents. We were never served with anything until probably about 6 months in. Okay. We weren't served with a petition. We weren't served with, obviously, the orders for the shelter order, the order for placement, all that shit that they made up. We weren't served with any of that because it didn't exist. We never were process served with any of it, which also strips the court of jurisdiction and authorization to do anything. Okay, so no certificate of service under Florida Rules of Juvenile Procedure 8.225 and Rule 2.516. Every pleading or motion must contain a certificate of service showing who was served, method of service, and date. A missing certificate of service is a violation of your due process rights. Any order without proof of notice was entered without jurisdiction. So that right there invalidates the whole fucking case. And that's just one of many, Okay, so this is what actual certificates of service look like. These are my pleadings that I filed alone. And I think one of them is my counterpart's attorneys. So on our side, these are our motions that we filed, okay, with certificate of service like they're supposed to have. So they can look like this, okay, but there has to be a certificate of service showing that you have served everybody else in the case with this document, or it's not a valid pleading. And this is the documents from DCF, which you will notice have no certificate of service. This is just 3 examples. Literally, none of them have a certificate of service. None of them. Okay, this is just left blank. There's a bunch of lines. There's just, that's blank. That's blank. And next, maybe one of the most important aspects of the whole case would be proper e-filing stamps. You have to electronically file the documents in the case. This is what it looks like when you file them electronically with the case and they are on the docket. If you've ever electronically filed something, you've done a case, this is what it should look like, okay? Once again, these are our pleadings that we did on our side, and that's the proper e-file stamp. And then we have the documents that DCF filed. You notice anything missing at the top there on each of them? The e-filing stamp, because they were never actually electronically filed into the system. Also invalidates the whole case and strips them of authority. This is order on arraignment and disposition. No e-filing stamp. You think that's an issue? I do. Now, one of the documents that they filed, this is what it looks like. On the bottom, this is an actual e-filing stamp. And on the top, that is somebody that typed in some shit to make it look like it was e-filed. Can you see the difference? Once again, perjury, forgery, fraud upon the court. So far, we have not even gotten to our first court date yet. We have not gotten to speak to a judge. We have been illegally GPS tracked by our phones without proper authorization. We have been illegally detained without any kind of actual legal court order or authorization of any sort. They just took it upon themselves to make up a bunch of lies and just bully us, basically, thinking that they were probably dealing with a bunch of stupid drug addicts or something. Found out very quickly that was not the case. They illegally seized my children with a fake court order that only had one child's name on it. So even if it had been authentic in any way, which it was not clearly, they still would have been kidnapping one of my children. Then they did not allow us to have a shelter hearing, which by law they have to, or it is a violation of your due process, and they lack subject matter jurisdiction. They did not serve us with the petition for dependency or any of the court pleadings informing us of any court hearings or anything literally until 6 months in, which also strips them of subject matter jurisdiction and invalidates the whole case. Okay. And then while we're waiting for it, they start entering in documents that are handwritten, that are forged, that aren't actually signed by notaries, and just all sorts of forgery and perjury. Clearly, the lies in these documents, we'll get into that in another video, are so crazy. It's like, who the fuck are these people talking about in these documents? They went and interviewed all of our neighbors, his family, my family, and none of them said anything bad about us, that they had any concern about us being a danger or anything close to that. And they still took it upon themselves to tell all of them that we were drug addicts. And then to say that we were evading CPI contact for the hours that had passed so far, and to do all of that illegal phone pinging and detaining in the Walmart parking lot, holding us there for 3 hours, traumatizing our children, etc. And then, as they are forging and putting these documents into the case, they did not electronically file them, which is not even legal at all. There's no certificate of service on anything. All of that is so much more than is even needed to throw this case out. It should have been a laughing matter. That's funny. This is not anywhere close to legal. You guys are obviously playing games. Haha, very funny. We'll take our children and we'll go now. No, we fought them in court literally for 9 months. And even at that point, I literally had to argue with the judge as I was defending myself because I was right. And he kept trying to tell me that I was wrong. and then eventually gave me my children back, but under their supervision. I had to comply with all of their bullshit. I had to, take their classes and get checked in on, and it was just ridiculous. My counterpart wasn't allowed to live in the home with us. It was the most illegal, intrusive, traumatizing experience of my life, and it is not anywhere close to legal. The things that these people do and have done, and they continue to get away with, to take children that there's no reason for them to even be involved with at all, is sick. It's absolutely sick. They are nothing more than a cover for selling them. Point blank, period. And they need to be stopped. And that's it. It is what it is. And the more people that become aware of this, the better, because they need to be dismantled. What they are doing is traumatizing children, traumatizing people. There have been parents that have unalived themselves because they got their children taken away. They got their parental rights terminated. They will terminate people's parental rights over nothing. They try to do it to us. We had to pay $5,000 for an attorney that was complete shit, just shit. And then even the attorneys that were good really didn't do all that much help because they don't care. You say, hey, you broke the law. Here is the evidence that you broke the law. And the judge says, no, I don't see it like that. I'm going to do what I want to do anyways. And there's nothing you can do about it, basically, because I'm a judge and you're not. Obviously, they don't say those exact words, but that is the intent behind it. And that's exactly what happens. So on the next video, we're going to get into some more documents and we'll go further into the case. Like I said, we fought these people for 9 months, took it to trial. I appealed it, the whole shebang.